इसमें लेटेस्ट जजमेंट महिला जो पूरे ग्राउंड को कवर करते हुए मिला महिला। नाम बताइए, पार्टी का नाम बताइए। महिला के नाम है शैलेंद्र कुमार वर्सेस यूनियन ऑफ इंडिया महिला। और एक आया है महिला जिसमें कि अगर पूर्व में कोई भी इनका सब वाजपेयी बता रहे थे ना कल अनऑथराइज्ड एब्सेंस पे विमलेश वाजपेयी जी को बुलाना जा रहा है। कौन मिस्टर विमलेश वाजपेयी और अभी होंगे कि नहीं होंगे क्या मालूम। दूसरा था महिला की अगर पूर्व में एक इंक्रीमेंट या कुछ भी ऐसा वो हुआ है तो अगर उसको इसमें वो मेंशन नहीं है तो उसका क्योंकि उसको उसमें पनिश किया जा चुका है इसलिए इसको नहीं कर सकते। कौन सा जजमेंट है महिला? यस। और इसमें एक और उसका कौन सा पैराग्राफ है सर? ये नॉट ये महिला पैरा इसमें आवास गांव में विभागीय जांच है महिला और पैरा 9 में इसको पूरा एक्सप्लेन किया। और इसी में एक जजमेंट साइट किए हैं 2008 कचार एमपीएलजे वो भी है उसमें महिला जो है ये उसको क्लियर किया महिला। इसमें महिला 2024 में 2000 एससीसी 2012 का वॉल्यूम 3 को साइट किया महिला। और 2024 कौन सा वाला? ये महिला झारखंड हाईकोर्ट का महिला। और इसमें 6 साइट की है महिला जो रिलेवेंट इसके 2012 का एक है महिला। ये पेज नंबर महिला 178 महिला। ये वाला देखिए मैडम आपने 12 का 3 178 somebody called Mr. Vilas Vajpayee. नहीं है क्या? मैसेज करो, the court is calling. Because in the case of 2-3 दिन पहले ऐसी अनऑथराइज्ड एब्सेंस का हमने डिसाइड किया था। उन्होंने बताया था कि एक रिसेंट जजमेंट आया है मतलब ड्यूरिंग द कोर्स ऑफ आर्गुमेंट इन फेवर ऑफ द एम्प्लॉई बट वो दैट वाज नॉट ब्रॉट टू द नोटिस बिकॉज ऑन टेक्निकल ग्राउंड द इंक्वायरी वाज सेटिस्फाइड।
Lordship. 2014 4 SCC.
Yes.
In this lordship, it is the facts are slightly similar, and it is about unauthorized absence only.
Where is the finding in that case?
In this lordship, para 22 deals with the willful absence part, and paragraph 24 and 25 are important, lordship.
Paragraph
24 and 25 also. In this lordship, the state of Punjab versus PL Singla is quoted, which is also Supreme Court judgment regarding unauthorized absence. Basically, lordship, the court has held that the punishment of dismissal can be given by the disciplinary authority. However, if the court feels that it is disproportionate to the case, in the case of the petitioner, depending on the facts and circumstances, and it shocks the conscience of the court, then the court can interfere with the punishment. In this judgment only, lordship, from para 28 to 30, they have also discussed the doctrine of proportionality, the test of the reasonable employer.
ये उनकी पुस्तक है क्या? इसको अपने ऑफिस निकाल 2017 है 2012 3 जी 12-3 एसएससी 12-3 178 इनको वापस करो। देखो the charge against the petitioner is quoted here in below. Annexure P2 page number 15 पहला दूसरा फर्स्ट। The admitted fact of this case is that the petitioner remained in absence from duty from 28 to 2013 to 16/10/2013. There is no dispute to the fact that the petitioner remained in unauthorized absence for that period, and he joined. He made his report on 16/10/2013. When his reporting was accepted by the respondent scholar, note sheet was prepared, reflected from the records within Bekatina, in which it was proposed that his absence will become in Nasti B, file B. It was proposed that, considering on humanitarian ground, on leave, the absence may be added in the earned leave. The superintendent of police directed that the matter be sent for inquiry. The note sheet also indicates that the petitioner had 246 days of earned leave in his account. अर्ध वेतन अवकाश को क्या बोलते हैं? अर्ध वेतन अवकाश of 480 days in his account. On the record, it appears that, on the records of the department, it appears that a charge sheet was issued to the petitioner with the above stated charges, and the copy of the same was delivered to him. The charge sheet also indicated the details of the witness to be examined and the documents to be relied upon. The petitioner submitted reply to the charge sheet, and thereafter the departmental proceedings were carried forward. Time to time, the notices to appear in the charge during the course of departmental inquiry was issued, in which was duly served to the petitioner, and he appeared in the departmental inquiry also. तो उसको मतलब फाइनेंशियल मतलब नोटिस वाज इशूड है ना. The witnesses were examined by the inquiry officer. Four witnesses were examined by the inquiry officer, which were not cross-examined by the petitioner. The petitioner was subjected to examination and cross-examination, and he also submitted his defense statement. On completion of inquiry, Department of Inquiry, the report was sent to the petitioner inviting his response. The charge number 1 and 2 was found against the petitioner. है ना? पहले उसको पहले लिखना ना. Ultimately, the white order dated to 2016, the petitioner was removed from the service. Post up. An appeal having been preferred against Annexure P2, also was appeal was also dismissed. White order dated 2019 to 2019. Post. The challenge in this petition is the Department of Inquiry and Punishment so imposed is not challenged on the ground that the petitioner was not afforded proper constitutive hearing, or the Department of Inquiry was not conducted in accordance with law. The submission, the challenge is on the ground that the petitioner had sufficient and valid reasons for his unauthorized absence, which have not been considered adequately by the inquiry officers or the disciplinary officer and the appellate authority. Next para. The petitioner has also not disputed that during the period from 28/2/2013 to 16/10/2013, he was absent from duty, and no intimation for his absence was given to the respondent department. The defense which has been put forth by the petitioner is that during that period, her wife was suffering from serious ailment serious medical ailment of cancer and other heart-related issues, and the petitioner was engaged in her treatment. Result, however, she succumbed in the month of May 2013, and thereafter he was under mental trauma and was also engaged in performing the social rituals. Could not join his duty till 16/10/2013. Next para. From the records of the department inquiry has also the writ petition. It is quite vivid that documents with regard to treatment of the wife of the petitioner are available. So, from the record, it is also indicated that in the note sheet, it has been observed that the case of the petitioner would be sympathetically considered and had sufficient on leave and other Shashki cash in his account. The next paragraph. The law with regard to department inquiry, law with regard to interference in the department inquiry is no longer res integra in light of various decisions of the Honorable Supreme Court. It is well settled that the High Court cannot sit as an appellate authority to reappreciate the evidence.
Lordship, in BC Chaturvedi, the same has been in paragraph 12 and 13.
मालूम है,
Lordship.
हम कुछ और लिख रहे हैं. मैंने उसको पढ़ रहा हूँ. 2022 ऑनलाइन वाला था ना SCC. तो कोर्ट ऑफ व्यू BC चतुर्वेदी में लिखा था ना अंदर में BC चतुर्वेदी, संजय कुमार शर्मा, सुब्रता नाथ, and many more judgments, and in which it has been observed as under the case in hand, whether this court can interfere in the findings recorded in the department inquiry and the order of the disciplinary authority and order of the appellate authority system. In case of Vishnukant B. Parmar versus Union of India, 2012 3 SCC 178. In paragraph 17 and 18, 17 to 18, this court has observed as under. In case of PL सिंगला कहाँ है? 2008 है ना? ये है. In case of PL Singh, State of Punjab versus PL Singla. Paragraph 12 and 13. तक. One more argument was advanced by Shri Pandey that the petitioner has put in about 23 years of service. Therefore, award of punishment of removal from service is disproportionate to the charge, and it should shock the conscience of this court. Honorable Supreme Court, after taking the stock of previous judgments in case of Chief Executive Officer, Krishna District Cooperative Central Bank versus Hanmanta Rao, 2017 to SCC 528, appointed as under paragraph 7.3. Yes, sir. Next paragraph. It is well settled that ordinarily this court should not substitute the punishment of enforcement of penalty to its own view, and the same should be left upon to the disciplinary authority in case the petitioner, the courts come to a conclusion that the punishment imposed is so shockingly disproportionate to the allegations leveled. Here in this case, the petitioner just tried to justify his long absence by placing on record the medical papers, the treatment of the medical papers of his wife. He tried to demonstrate that his absence was not, though he may be unauthorizedly absent, but the same could not be termed as deliberate or willful. The inquiry officer found the charges leveled against the petitioner proved and gave a categorical and gave a finding that and should have placed on record the death certificate of his husband, his wife. He also gave a finding that medical form number 3 dated 10/8/2013, 11/9/2013 and form number 3 dated 15/10/2013 was sent by him. But he gave a finding that the petitioner remained absent without any intimation or approval. Without any intimation or approval. Stop. It also gave a finding that the petitioner was directed to, he was relieved for police station Bhopalpatnam from Bijapur on 28/2013. However, the petitioner, without any intimation, remained unauthorized absent from his duty for a long period. Stop. Though there is a finding that the petitioner remained unauthorized absent, but the finding in the regard that his absence was unauthorized and needful in light of judgment of Krishna Kanjur लिखा ना वाला उसका अब हम इस पे थोड़ा थोड़ा देखेंगे इसको कॉन्शियस वापस भेजना है कि पूरा सेटिस्फाइड करना है उसको थ्रू
Lordship, the judgment that Lordship was asking Mr. Bajpayee has informed SLP Civil 20817.
I have sent a copy to the reader.
उसको भी देख लेंगे
Lordship.
SLP
Civil 20817 of 2022.
817
20817.
date
4th September 2024. 4/9/2024.
49
Yes, 2024.
इसको निकालना है बनाएंगे अंदर में. Let me apply my mind whether I should set aside or I should remand it back.
Lordship.
Yes. Back.
However,
I should dismiss.
this SLP was different, my lord.
Huh?
Gone through the order in the SLP. The issue in the SLP was different. It was with respect to satisfaction, recording of satisfaction of the authority after issuance of show cause notice for initiation of DA.
Maybe he was
Yes.
telling me something, na? Therefore
Yes.
I just उसको सब रखना है, मैं दिखाता हूँ मैं.